This great institution. A very good afternoon to one and all. And most respected Vice Chancellor of this great institution, respected Registrar, respected members, those who have come here, and expert members for this great day, the IQAC members and learned faculty members of this great institution. A very good afternoon to one and all. And I'm so glad in welcoming our Vice Chancellor, who is the motivator and he is helping in every aspect of growth and development of this university for everyone, each and everyone who goes and asks anything, and he is readily accepting things, and he is the first person leading or motivating everyone who is seated here. And on behalf of everyone present here, I extend a warm welcome to you, sir. I also welcome our respected Registrar in charge, Dr. Ramakrishnan, and who is also a very good motivator as well as helping in all aspects. And whatever the program which we are organizing, is the person humbly says and kind enough to give us any help and whatever we ask. So he is also a good person, which both of them are leading this institution in a very good way, as well as they are giving a very good support in all ways and means. So on behalf of everyone present here, I extend a warm welcome to you, sir. And I would like to welcome the guest speakers or expert members, those who have come here to have a talk on awareness program on intellectual property rights. So this is being the first time in the university we are organizing this kind of program. So this is the first forum where we are all meeting together. And I was approaching since last week before, we had our LTP program where Mrs. Gayatri, person from JPIS, came here, and she gave me one number for this IP cell formation and so on and so forth. So I contacted that person, Ratna, Mrs. Ratna, who is there in Hyderabad. So she said that I am having certain numbers in Chennai itself. Why don't you call them and speak to them? Then she gave your number, sir, Mustafa sir, and in such a way I was having the rapport with those people, and at last I could able to find out you. So from you, the other persons, they have joined here today. So this is the university, this growing university, developing university, where we need to have all these kind of facilities and cells, especially towards the research, etc., etc. Almost all the staff members sitting here are holding PhD and they are guiding people. So it's the right time for every one of us to know about these intellectual property rights, and you are the experts those who come here to give us the knowledge, inputs, how to go about with this. So we extend a warm welcome to Dr. Mustafa and Amrita and Ms. Lata from IIT Madras. Let us all give them a big round of applause. Right? Thank you very much, all of you, for accepting our invitation. And I also welcome the organizing secretaries of this awareness program, Dr. Tirumale Kumar and Mr. Srinivasan, those two are organizing secretaries, and all other members of the IQAC and the criteria heads, those who are sitting over here, and all other faculty members of this great institution. Once again, I welcome one and all. Thank you so much.
Now I invite Dr. R. Ramakrishnan, Registrar, for the felicitation address.
Respected expert member from IIT Madras, respected IQAC Director Dr. Grace Helena, and all faculty members. very good afternoon to you all. In respect of NAT affiliation, the IQAC director and the core team members are seriously organizing a variety of programs from the past 1 month. I take this opportunity to appreciate first the director as well as the core team member for the dedicated and sincere work taken towards this regard. So, in this series, a variety of program is organized. One of its kind is the IPR, Intellectual Property Rights. We all know that what is property. Property. Everyone, we are having the property. That means properties are different kinds. Mainly it is classified into 2 kinds. One is called the physical property, another one is intellectual property. So, the physical property is the property which is earned by the individual or it has been received from the ancestor. That it may be movable property or immovable property, that we all know. So, we are preserving or protecting this property. We have certain documentation that we all know. If we want to be a owner of a land, for example, land or building or any other asset, we have to register in the competent authority. For the registration office, we have to go for registering the purchase of a land or any other building, etc. Then only we can claim or we have to be an absolute owner of the particular property. Any things going to happen in future or any legal issues arise, then only we can claim if it is registered. That is one kind. For protecting or preserving the property, the physical property, we know all what is the procedure we have to follow. On the other hand, the other property is called as an intellectual property. That means the property earned by means of intelligence. The human intelligence, we are acquiring certain property, that is called as an intellectual property. The more elaborated discussion should be made by the expert member. Just I will give you a brief introduction what is called as an intellectual property. So, in order to protect the property earned by means of intelligence, what are the things we have to do that are going to be discussed in today's session, that will be going to take care of our 3 expert members coming from the IIT Madras. So, on this occasion, I request all the faculty members make use of these opportunities effectively and how to register for patent, trademark and other things are going to elaborately discuss. So, whatever the innovations you are going to do in your research and development and all, we have to go for the registration. The means of how to approach the owners. It is the intellectual property authorities. It comes under the government of India control. So, what is the procedure, formalities, what are the regulations to be followed, and what are the things are eligible for applying patent, what certain things are not able to go for patent and other things you can go for trademark, etc. So all the things are going to be discussed elaborately today. So this occasion, I, on behalf of this university, once again I extend my warm welcome to the expert member, and also I appreciate the sincere and praiseworthy effort taken by the director IQAC and the team members of the IQAC and all the faculty members for making this function as a grand one. Thank you.
Thank you, sir. Now I invite Dr. M. Sundar, Honorable Vice Chancellor, for the Chief Guest Entrance.
Good afternoon, everybody. I'm really very happy that we have 3 expert members today in the afternoon session. So, our minister has explained very clearly about the physical property and the intellectual property, and we have got experts who will be explaining in a better way, who will be explaining it in a broad way. So they are there. I thank our IQAC coordinator for making all these arrangements. And I'm sure that the staff are all working well. And I also request you all to concentrate still better and work more so that we achieve our. Thank you very much.
Good afternoon and a warm welcome to one and all present here. It's a pleasure to welcome you all, and especially welcoming today's speaker. It's a great pleasure to have you here, sir, Mr. Mohammed Mustafa. A few words about sir. Sir is a senior manager, intellectual property management cell at IIT Madras. He's a graduate from Loyola and with a Bachelor of Biotechnology, and further he's completed MBA in University of Madras. So he has an overall experience of 10 years in intellectual property services and team management. So he's here to share his knowledge and help our university progress. So I'll hand over.
Vice Chancellor sir, respected Registrar sir, respected Madam, a very warm afternoon, and thank you first of all for inviting us and giving us this opportunity to share this dais with all the respected faculty members here, along with you, Madam. So it's a real pleasure to meet everybody here, because we deal with a lot of people in IIT Madras, but this is something away from us. So I'm very happy and glad to meet one and all here. First thing is, when I stepped into this university, I was only thinking about sports means only physical education. So blankly I had nothing in my mind to talk about sports as such, but I was largely I wanted to discuss more on intellectual property, patent, designs, and how we can formulate a process around this. But after meeting Madam has given me some insights that there are so many branches around sports. We said sports technology, sports physiology, psychology, psychology. So many different things happening around this, and I am sure that there is so many interesting research also happening around this. So it becomes important for us to, kind of protect each and every what we are doing in this university, and at the same time claim the credits and value out of that research. So initially what is happening is, largely in the engineering and scientific community, people are developing new innovations, new interesting products, interesting process, and we are just publishing out there in the papers, form of articles, journals, publications, which is becoming another source, technical source for the companies to build their products. So initially these products have to be built at the academic level. So what has happened is, gradually the government of India and economics governments have built a very good innovation, entrepreneurship, and intellectual property ecosystem as such, to facilitate the research and development and to protect the intellectual property that is generating out of the institute. So largely we are trying to capture all this support system in IIT Madras, and briefly I will talk about my experience and largely open up for an interaction and discussion with all of you. So shall we begin? Let me begin with the great news that's happened to IIT Madras recently, sir. Just last week, IIT Madras has been granted the National Intellectual Property Award for the year 2021 and 22. IP in IIT Madras started in 1995. 1995, first patent we filed. And after that, there was no activity that was happening for last 10 years. 2005 it was a very dull activity. Then 2005, we started filing 5 patents every year. Just 5 patents. In last 5 years, we are filing 150 patents every year. So I'm very happy that government has recognized this, and we have been given this National Intellectual Property Award for the institution, best academic institution category. So they are also part of it. So let me take it to another interesting news that has come out on this. What was happening is, in India, there were about 50,000 patents filing happened every year. 50,000 is very less compared to US or China. China is doing something around 15 lakh patents every year. 15 lakh. And US is doing around 10 lakh patents every year. India is just 50,000. The irony is, 80% of the Indian patents are coming from foreign. Foreigners are filing in India. So, Indian domestic patents is only 20%. 20% of 50,000 is only some like 10,000. So, this was the kind of innovation that is happening in India, only 10,000. So, what government did? Government made a lot of changes in the IP policy, in the amendment, patent amendment, that it has now given rise to more domestic patents. Now, Indian institutions, academic institutions, colleges, universities, Indian innovators started filing more patents. Now, the domestic patents have gone up than international patents. This is one of the good news. And also about the trademarks. This is one classic example how many companies have come up in last 5 years. In last 5 years, nearly about 12 lakh patents, 12 lakh trademarks filed in 2015, and now every year 12 lakh patents are being filed in 2020. So, trademarks. Trademark is nothing but registration for a new company or a new product or a new logo. 15 lakh new products are coming in, companies are starting. So this is also a good sign that we are moving towards the right direction where we are protecting our intellectual property. This is one of the same. Sir explained about physical property and intellectual property. So largely we understand this as tangible property and intangible property. So what companies are doing? So there was a survey on the Fortune 500 companies and the assets they are keeping. So what was happening is these Fortune 500 companies are now having 80% of their assets in the form of intellectual property. Only 20% is only the physical form, like you said, the buildings, the resources, the systems. Microsoft in India is owning no offices. Whatever assets they are owning now is in the form of patents, trademarks. We know the famous case of the Kingfisher. The Kingfisher logo was sold for 18,000 lakhs. So that's how we are. So these brands are having more value, that is the intellectual value, than the physical assets. This is one of the examples. Thank you, sir. So I'm just taking you through roughly. This is one of the very strong representations to understand the power of intellectual property. Just by looking at this logo, we all know the brand. So we know that this is Coke and this is Apple. It is not written there, but just by seeing the logo, we can identify this. This is how these brands are penetrated in our daily lives. This is the power of intellectual property is creating. Let me briefly take you through the importance of IPR in an educational institution, especially patents. Patents disclose a lot of technical information. As I said, patent covers the background of the invention, the patent. When we are drafting a patent application for filing patent, we cover the technical prior. What happened before the technology? What is the current trend? And how we are trying to come up with a new invention. So it has a lot of technical information. Then it is present in the form of publications or papers. So, patents are a good source of technical information. Second thing, intellectual property will stop mass reproduction, copying or infringement. Suppose there are two people, suppose our institute is developing a research, as I said, we are sports technology research, so the racket technology you said. So, sir is developing some technology and composite material for using the racket. Similarly, if we find another institute also working on the same composite material, the person who is filing the patent first will get the rights. So there was a concept called first to invent. Before having all these laws in place, this protection will go to first to invent. Now, after having this law, the protection or the rights will go to first to file. if you are the first person to file the intellectual property, then it belongs to you. No matter if your invented is 10 years before or 20 years before, if you are not filing, it doesn't belong to you. So you can stop others from copying your idea. It will help you to start your company. Now, this is the trend in IQAC. What is happening? Students and research scholars have come approaching the IP cell to protect their ideas, product, invention. At the same time, they are coming with a startup plan. They say that I am having this product, I am going to start a company. I am going to incubate my company. I am going to we are founders for this particular invention. So it helps you to start a company, get funding. Especially now this trend is increasing. Sir. Everywhere we find the institute itself is allowing its faculty members to start a company. I don't know how many of you are aware. It's almost in every engineering college is there. So the college is encouraging the faculty members. They are coming up with interesting ideas, new products. They can form their own company, startup company, and incubate in their own institute. So this is one of the trends. Of course, like any other property, you can sell this intellectual property in the form of licensing. So, suppose, sir, if you feel that you don't have the infrastructure and resources to build this technology or manufacture the rackets, you can license this technology to any company and get a huge returns out of it. Huge returns. So IBM, we all know about this company, International Business Machine. IBM, 80% of the IBM revenue is coming through licensing. They are having an R&D team, they are creating new innovations, they are selling it to the companies. Then 80% of the revenue of IBM is coming through intellectual property. So we don't have to think that we have IP, we have to make a product and sell it. IPR is an interesting career. So any person who is a science graduate, engineering, or into technology can have a very good career in IPR. So for all these reasons, we always emphasize that students and research scholars to learn about IPR. So the IP as a way, it can be assigned from one person to other. It's a property like any other property. Just one thing. A broad classification about IPR. Like sir said, patents are one form of IPR. Also mentioned about trademarks. So intellectual property is an umbrella term where a lot of other properties come up. Like engineering, we have mechanical engineering, chemical engineering. So under IPR, we have patents, designs, trademark, copyright, geography. Now we all are doing different types of research. So we all may have the impression that we can only file a patent for this technology, whereas there are other possibilities like design. Suppose if you come up with design for shoe sole or interesting. I had this opportunity to meet one of the scholars who happened to do a research on rehabilitation for people with flat foot. He has come up with a design of the shoe sole which will help to minimize this kind of pressure on them.
There in IIT, Dover.
Exactly.
Canada.
Okay. So we can protect that particular design, IP in the form of design. You don't have to do much things like patent, in the information for designs only photographs, images of your design, CAD images, the design office will do and we will do the protection. So in fact, I would take one step ahead and ask you, what is stopping us from filing a patent? The burden to prove that this is not a patent lies at the patent office. The patent office or the patent controller who is examining the product, he has to say this is not a good patent, this is not eligible for a patent. So whatever interesting technology, research we are doing, like first thing what we do is in IIT Madras, we go to all the research scholars and try to find out what kind of research they are doing and is it possible to protect their research in the form of patents. So the first thing what we can target is the PhD scholars or the research that we are going to publish in the form of theses. So that is one thing. Quickly to go through this, patents can be filed for product or processes which should be new, unique, not existing, in the form of publications, papers, etc. It should have some commercial application. Who can apply for a patent? Any person. Any person who is claiming to be an inventor, a company, large entities, academic institutions, everybody can file a patent. So there is a misconception among the students that the patent should be filed by faculty, patent should be filed by professors, only scientists. So we don't have that right. So these are some of the examples of design registrations. You can file a design for a shape, configuration, pattern of lines, colors, for anything. So bicycle, there are hundreds of designs. Car, I-10 is different from I-20. I-20 go to design registration with I-10 with jewelry. If we take the right from the necklace, haram, earrings, the design registration of one company like Kazana Jewelers will be different from Lalita Jewelers. Hundreds of design registrations they are having, so that they stop this competition between themselves and they create an IP protection for them. So this comes under the design registration. Trademark, as we know, all these logos we come across day-to-day life. We see these, everything we see around, everything we use has come to the patent office, I should say, are protected in some form of IP. Right from the mic I'm speaking, I'm standing here, the chair which we are using, the television, everything is coming up. So these are some of the well-known trademarks, I should say. So next one, the copyright. There is a very clear distinction in laws: patent, trademark, now copyright. So anything that is related to literary work, dramatic, music, art will come under the copyright. So this is also an important right where we can claim. So now there is a huge fight in the Bollywood and Hollywood industry. Who will sing the song? This lyrics belongs to which person? Who is the music director for that? So between these three people, there is a fight among who owns the copyright for that. Whether the music director or the lyricist or the singer who is singing that song. So the law has clear distinct between who owns that copyright. So there is a lot of debate around it, and the simply saying. So this kind of work comes under the copyright protection. Another interesting protection we have here in India is geographical indication. Geographical indication is not a one-person right. This is a community right. For example, if some signs and symbol belong to a certain community of people, certain area or certain region, then the group of people come together and protect that IP. For example, Kanchipuram sarees, Tirupati Laddu. So there will be an NGO who will come forward to protect that. This particular design, this particular origin of this sarees belongs to Kanchipuram. So they will protect this name, Kanchipuram sarees. We have around 400 plus geographical registration registered in India. So you can go and find details. This is one classic example. You can find it everywhere. And the one product you can find all forms of intellectual property. You see the camera, you see the chip, you see the semiconductor inside the phone, all are protected by patents. You see the manual, you see the the sound, you see the color, it is protected under the copyright. The logo, the texture, so the brand name, slogans, everything is covered under trademark. There are any idea how many patents are filed by Apple every year? Apple has a force of IP enforcement and IP prosecution team. Because we all are aware of this very famous case of Samsung and Apple battle between us, so finally they settled it up. They lost his, Samsung lost his. So it's because of this. It was possible because Apple realized this, that There should be intellectual property even for small, not necessary that all IP should be present there, but some IPs will be there. So, okay, anyway, so there is a small difference between invention and innovations. So when we are filing an IP, it is important to understand what is the difference between an innovation. So what back office says, an invention is anything new. The definition for invention is present in the Patent Act. But the definition for innovation is given by WIPO. WIPO says innovation is doing something new that improves a product or a process that can be protected through intellectual property rights. So any improvement you give to the existing process, existing product, will form as an innovation. Yes, small modification, but it should give some advantage or some new benefit to the existing product. So I'll just give you some examples. We all know this. This is a very classic example of a patent. This is the paper clip. So many people did not know that there is a patent for this. It's a simple piece of wire bent in such a way that it can hold a bunch of papers. That's simple paper clip. There was a patent because it has a use. Right? People did not stop with this. There was no, they think that okay, there is a paper clip, there is a design. No. There were still more new patents coming up on this small innovation, small, like you said, small modification, small improvement. It did not stop with this. Came more. More people started inventing new modifications, new designs, and this. So now we imagine we are doing so much of research, so much of improvements. Why can't we go and file a patent and claim patent rights for that? So, there is another interesting invention for the mouse. Computer was first filed a patent in somewhere around 1960s. Then telephone came. Then there was another interesting patent filed by Microsoft in the 1980s. I mean, even before that, double clicking of the mouse. There is a patent on double clicking on the mouse. Nobody can even imagine that this today become revolutionized our computing world. So they thought that this would come up one day and become a common thing. So there was a patent around double click. That's how patents are futuristic. So many people have this misconception or idea that I need a working prototype to demonstrate that my idea is working. You don't need that. Patents are futuristic. They are developed today and worked out 5 years or 10 years later. I give this example of 3D printing. 3D printing technology came around 1980s itself, but it actually came into industry somewhere around the first half of 2000, 2004-5 started coming up. So till that time, people were working on that, but they did not realize the importance of this 3D printing technology. So whatever research work you are doing right now may not become a product the next day or the next year, but definitely it's going to become a successful product or a blockbuster in another couple of years. So it is important to protect the intellectual property. So sir asked me, so what will happen if they have a small modification? Is the small modification in the patent or the invention help you to reduce the time? Then it is a good improvement. If it helps you to improve the process or improve the speed, improve the efficiency better, then it becomes patent. If you are able to integrate a couple of process together, product together to give a new product, to give new solution, it becomes a technical advancement. Okay? So a longer life, additional functions, reducing the waste, reducing the cost. Suppose nano-composite material will reduce the weight as well as at the same time reduce the cost. So it becomes a technical advancement and it fulfills the requirement for filing a patent. So let me come back to my IP cell. So that is one objective of our meeting, about to tell you exactly how we have the process for capturing innovation in IIT Madras. We have 4 wings and we work together. IP cell is one, IP marketing, legal cell and patent attorneys. In IP cell, we help to create awareness among the students to bring new innovations to the IP management cell, where we do two types of things. One is docketing of IP and recording of IP. Second is IP operations, where we handle all the communications from the patent office, right? Because most of the inventors may not be aware of kind of communications that are coming, technical communications, because the law says, the patent law says, every process that is involved in patent filing is time-bound. If we don't respond, or if we don't reply in a given time, then our patent or IP becomes abandoned. The patent office will not respond. It's like playing tennis. You play your shot, then patent office will play their shot. Unless we don't respond it, they'll say no, you are out. So what we do is we facilitate the inventors in this communication. So they just have to disclose their invention, and the rest of the things is handled by the IP cell. And in certain cases, there is a joint and collaboration IP. Like now your university may work with other universities. Like you said, you can have a collaboration with IIT Madras in some mechanical department or some metallurgy department, where they are working in some new materials, and then there is a joint IP, collaborative IP. There is, I think, huge possibility of collaborative research here, because what is happening here will not happen in any other institute outside this. So their focus of research is something else. Their focus of research is to build products, take it to the industry. But they will not think in a way whether these new products or any inventions will be applicable in sports or games, or the equipments or the facilities or the sports technologies. So you can reach out to the other institutes to have a good collaborative setup, where you can develop new IPs, new product and new research. So that is one of the areas where we are working together. So in such cases, we need to take the legal help to create an agreement between two institutes. We call inter-institutional agreement, the sponsored research agreement, etc. Industry consultation agreement. That is one of the areas where we are getting a lot of revenue for IIT Madras. Industry consultancies. So some company will be facing some problem in their process. They don't know how to overcome this. So they will give good grants and funding to IIT Madras professors to find out a solution for that. That's kind of an industry consultancy collaboration. That's one area where our professors are getting a lot of good projects from the industry. So I'm just taking it out of the context, but my point is to cover most of the things here. So we work with IP cell, legal cell and IP marketing. So once the invention is filed, once the patent or a design is filed, it is important to go and take it to the industry to know if this product can be useful in their value chain, whether this product can deliver some useful solution. So our IP marketing team does take some good effort to reach out to the relevant industries or relevant companies. Suppose we are building a rehabilitation device, physiotherapy rehabilitation device. We have a center for research in rehabilitation. Sir, IIT Madras is having 30 centers of excellence. 30. So as I said in the beginning, IIT Madras is more than an academic institute, it's a research-centric institute. A lot of research is happening across. So what we have done is gradually they have built one center for that particular research. For example, research on e-mobility or electric vehicle, there is a center for excellence. There is a center for excellence in railway research. There is a center for excellence in rehabilitation, non-destructive technology, and so many. And another interesting thing that is happening in Hyderabad is there is a entrepreneurship and innovation clubs. There are at least 5 entrepreneurships and innovation clubs that are open to the students. We call it Center for Innovation, Entrepreneurship Cell. So the purpose of all this is to capture the innovation. So from the from the government level, they are creating a kind of ecosystem and support in terms of availing the benefits for intellectual property, availing the benefits for getting the funds for research, giving the good research grants. So this has to drill down to the institution level, where at the institution level we can create setup where we can allow students to come forward and share their innovation and ideas. So what happened is, it was too late for the government to realize that the fundamental research or the basic research is actually happening at the institute level, not in the company. So the pharmaceutical industry, where there is a rapid innovation that is happening, the foundation for that research is actually the academic institutes, academic research. So it is becoming important for us to have an IP at the academic level before it goes to the industry. I'll just finish it off, then we'll take up some questions. So this is one of the ecosystems we have formed. So we have a good awareness system where we reach out to the students, faculties, outside companies, potential licensees. We have a system where we have created a process in such a way that every communication is tracked, monitored and managed. We have a very responsive process. We have search tools. Suppose a student or inventor comes up with a good idea. They want to know whether this idea is existing before, whether there are similar patents or inventions available. So we give them tools to do the search. So we have Google, like to go and do a search. We have Google patents for a free search. Similarly, we have Excel pad, Orbit. That's a kind of a comprehensive search system, which is subscribed by IIT Madras. We give this facility to the inventors. Of course, we give good rewards and recognitions to them. We are taking marketing efforts and also publicity. So if you look at the LinkedIn of IIT Madras, last 1 year, rampant campaigning, a lot of marketing, promotions. Now, a lot of institutions are realizing that and they are actively participating in this marketing and promotions of the activities that is happening around the institute. So maybe that's one area you can focus to get more industry attention, government attention, and also attract good funding. So at IPM Cell, what we do is basically patent assessment. When we receive a new idea, we do a search to understand whether this idea is new and novel. Then we provide them a report. We call it prior art report or novelty report. ஒரு செக்லிஸ்ட் மாதிரி சார் என்ன பண்ணோம்னா அது ஒரு ஐடியா வந்து எங்கள் டூல்ஸில் ரன் த்ரூ பண்ணிட்டு we give the report that இந்த ஐடியாவில் 3 elements A, B, C ன்றது new. So this A, B, C is already present in this publication, this is patent report கொடுத்தா what they do is they come up with an improvement. Okay, so my A feature is already present, let me change that. So they will modify their invention and try to file as a new IP. This patent assessment is IP operations. Of course, we do the filing in-house, trademark design ellame internal nam file pandrom. We communicate to the patent office. We docket and keep a record of every IP and every communication that is happening between the student, institute and the patent office. Third thing is we do IP marketing. So this is some of the IP activities we do at IIT Madras. This is the process flow, how a student approaches with an idea and finally how it is granted as a patent. So every idea is received in the form of a disclosure form. We call it invention disclosure form, receipt of ideas. Then it is reviewed by the chief manager of the IPM Cell. Then we do a prior art search and patentability search to see if it is patentable or not. So my team will actually take you through the process of patent filing and what is patent, what are the eligibility for filing a patent. And we prepare the forms. Patent filing, it's little complicated process, to be very frank. Patent filing is a challenging and complicated process, but once we do 1 or 2 filings, then you are used to this and you know what are the information you need to provide for filing a patent. So initially I would recommend, madam, you can take the support of a couple of patent attorneys and agents for filing the patent. Then gradually you can have internal members themselves coming forward and filing the patent. So we take for every IP file, we take our dean's approval or head of the department approval. Then we prepare the form, we do the filing at the patent office, and we market this in our AI system. I have covered this. So these are some of the initiatives we take to attract students, to bring more ideas. We do regular IP programs. We simplify the patent disclosing process. So idea disclosure. Invention disclosure form is idea actually. We ask a lot of questions. If I'm too fast,
Comfortable.
Right.
please let me know. Please stop me anytime and we can have interaction. So quickly to take you through this, there's some of the initiatives we do. We make the process simple. We have discussions. We get a lot of new ideas through discussions. So every time the student comes or a research scholar or faculty comes with an idea, we open for a discussion. We have a lot of idea exchanges, brainstorming sessions to help the students in idea discussions. We do the online filing. So it is pretty simple. So if you have one person who can take care of the online filing, it's like filing a government form on some website now. It's just you have all information with you. You just have to upload that information and some documents. That's it. So you can have one person to do an online filing for you. And most importantly, we take support of a panel of attorneys. We have around 7 to 8 law firms, attorneys, who help us in doing this patent. So I'll let you know how we do that. There is a process to empanel them in our process, and some new technologies. There are a lot of emerging technologies coming out of IT industry. So in such cases, we give it to the attorneys. You see this course, madam, it's called Patent Law for Engineers and Scientists. I think faculty may have heard of NPTEL. NPTEL is another online government portal for free education for students. All the courses that are available on NPTEL are taken by the IITM faculty. So this is one of the courses, unique courses on patent law, which is taken by one of the professors. So what is happening is, in the last meeting with the MHRD team and our director has requested the MHRD team to make this course mandatory for all engineering and science colleges. So this is going to come as a 4-credit or 2-credit course. So this is available on NPTEL and SWAYAM, which covers most of the part of IP. Any questions? You can find your answers. This is another course that is available on the World Intellectual Property website, WIPO website. This is also free, a certification course which covers most of the part of intellectual property rights. So it's a very valuable certification. We always recommend the students and research scholars to take this course. So, where we can find IP, we have 4 patent offices in India, Mumbai, Chennai, Delhi. Like sir said, there is a patent office in Guinea. So they are, unlike any other government organization, they are very friendly, very inventor friendly. You walk to them, they'll give you all the information, they will help you with everything. So this is my experience. The other's experience will be fine. So we have an office in Ahmedabad as well. So all the events that happens to a patent is covered in the Patent Act. So there is a law. That law is provided in this Act. We have a Patent Act, Design Act, Trademark Act. Certain things are confusing between the Indian law and the US law. Because if you look at the US law, the patents and designs are the same at the time. Because now we have a clear distinction between Indian law, a clear distinction between the patents and designs. So I have kept it very short. Thank you. I'm open for.
What is the eligibility, or is all invention eligible for patentability? So there are three important patentability criteria. One is, we call it as novelty, next is the inventive step, and third one is the industrial application. So your patent documentation or your patent application will be screened on these three criteria. So let me go through novelty. So when I take novelty, so as we saw, every inventions cannot be started from scratch. So everything has to be built on an existing product or process. So most of the invention doesn't start from scratch. So I have an existing product or I have an existing process. So I make some enhancements or I bring in a new feature in that existing product. Then what do? I find that new feature, or I find that the optimized result to be something new. So then my invention passes the novelty criteria. So that existing feature, the feature which you all found out, shouldn't be existing in the public domain. And second is inventive step. So any technical advancements, you have an existing product and I bring some technical advancements. Say I'm making it lesser weight, or I'm using new raw materials. So some technical advancement or any economical benefit. Say not only in monetary terms, say even it can be a process which gives you a zero waste, or a product which is uses a green technology. So any economic significances. So when your product gives a economic significance or any technical advancements or both, then my invention passes the inventive step criteria. Next is the industrial application. So this industrial application is, so when you develop a product or process, if it gives, if the applicability is, it gives a societal usage is, the societal usage or the commercialization will give you an added value. It will give you an added value for your grant of the patent. So when you find it, it's very useful for the society, or you can commercialize it, and it's very useful for the industry. So this added value will give you an advantage for getting a patent. So there are few stages and procedures involved going in while filing an application in Indian Patent Office. So before filing, internally, so either the inventor or any IPM cell at the institutes or at the corporate bodies has to perform some internal process. So first step in that internal process, we call it as IDF management. IDF is nothing but invention disclosure form. It's nothing but a template which contains the raw format of your invention. So like say, what is the problem identified in the existing system, and what is the solution which I have arrived, and description of that solution, and what are the advantage of that solution. So this will be the content of the IDF form. So once this IDF is being filled, it has to be docketed and given a reference number. So this this reference number can be used for later purposes. So after IDF is being docketed, a formal or informal meeting can be set up between the inventors and IPM cell, the intellectual property management. So the main objective of this meeting would be to know more about the invention, because more than the document, the communication between direct communications will give you more information. So a formal or informal meetings can be set up. So once it's been set up and we have gathered, the IPM cell has gathered necessary information, then we go in for the step 2, which is called as prior art search. So prior art, it's nothing but existing literature. So I have an invention here. So what my objective of this search would be, I'll search whether any existing product or the process which are there similar to the invention which is being docketed in my IDF. So the result, the outcome of that would be a patent literature or a non-patent literature. So non-patent literatures can be a journal publication or it can be a conference publications, all this. So, and when I find anything, so the result of it will be like, first thing, I may not find anything similar to your invention. So then I can directly jump into my filing process. Say, I have found something which is similar to my invention. So now what do I do? So if the inventor is able to differentiate his invention over that cited documents or over the cited technology, and he finds there's ample amount of differences, then I can go for a filing. So then there's one more chance, that is the cited documents are almost similar to my invention. So in that case, what happens? I have to fine tune my product or process and I have to go for a later filing process. So it's like a screening before jumping to the patent office filing. It acts as a screening so that I can either decide whether I can file or fine tune it and file it later. So, and next one is drafting. So drafting is nothing but preparing a documentation. So we call patent documentation as techno-legal document. So technical details in a legal way. That's how we call it as a techno-legal documents. So these documents are of two types. One, it's called as a provisional application, and one, you have a complete application. So what is this provisional? So when do I go for a provisional? Say I have an idea and that is at only a starting stage. So I have started something, I have obtained a result, but I am not satisfied. I wanted to fine tune more. Then what do? I file a provisional application to seal my priority date, because it's always first come. First filing has the right ownership of the patent. So I file my priority date. I seal my priority date. So when do I file my complete specification? So here what happens? My invention is almost completed. I have obtained the desired result, and the output is satisfactory to the inventor. Then I can go for a complete filing of a complete specification. So either the in-house team can take care of the drafting, or attorney law firms can take care of the draftings here. So we have drafted and our patent application is ready. So next stage is,
One second.
No problem. So just wanted to add one more point to what Madam said. There is a wonderful provision in the Patent Act, patent law. It's called provisional and complete. Quick filing. Sometimes we plan for a publication in 1 week. 1 week நம்மளால patent file பண்ண முடியாது. அந்த நேரத்துல நம்ம என்ன பண்ணலாம்னா provisional application quick-ஆ within 1 day இருக்கிற information அப்படியே கொடுத்து patent file பண்ணுவோம். So it's called quick patent filing, provisional application, where you don't have to supply detailed information in the form of diagrams, claims. So what happens is provisional file பண்ணதுக்கு அப்புறம் quick patent office gives us 12 months time to give the other details. Claims or diagrams or drawings, you 12 months ago. But you priority date, publication, munnadi patent file பண்ணிருக்கீங்க we get the date. It's one provision that also helping IT because a lot of students they come on the regular basis to say we have the emergency to take it to the industry, publications, something they say we need more time to develop this. Such we avoid provisional applications. One way we can.
I'll take it. So, next is the stage 2. It's a IP filing and prosecution. So, in this stage, the patent office officials, inventors and their representatives will take part, will closely work towards our patent grant. So, first step is patent filing. So, you have drafted a provisional or complete specification, so you have to file it. So, where do I file it? And how do I file it? So, either I can go for a e-filing. So, this e-filing is done through Indian Patent Office website. You have a comprehensive e-filing website, so you can directly do an online filing of your application. Or I can do a physical filing by walking into the patent office. So here, as sir said, the important catch is if you are submitting your provisional application, within 12 months you have to submit your complete specification. Otherwise, your provisional will be treated as amended. So you lose your priority date. So the next one is patent publication. So irrespective of all patent which is being submitted, it will be published. So where would be it published? So again, in the Journal of Indian Patent Office website. Every Friday they make a publication. And what do they publish? Only the complete specification, not the provisional specification. Only the complete specifications will be published there. Say, when would be published? So this question, like, it will be 18 months from the filing date, from the first filing date. So here, the patent office have come up with an expedited procedures. Say, I can't wait for 18 months. I want it to be published immediately. Then they have given an express way to publish. So they have few forms to be submitted, and you can expedite the procedure. By submitting the form, within 1 month, your document will be published in the Journal of Indian Patent Office. So once publication is being done, you have to submit a request for examination. So patent examination. Unless you submit your request for examination form, your patent application will not be examined. So it's only after submitting the request, your patent application will be examined. So here, once the form has been submitted, the examiner will be allocated and he will be giving the examination report. So what will be in that examination report? Again, he will be searching the documents based on the 3 patentability criteria: novelty, inventive step and industrial applicability. So this search results will be documented in the format of first examination report, which is called as FER. So again, say our invention lacks some novelty or some inventive steps which is already existing in the existing technologies. Then he'll raise some objections, and those objections will be cited in the first examination report. So once the examination report is ready, that examination report will be passed to the inventors. So here the inventors has to reply to the objections which has been raised in the examination report. So he has to say, he has to give reasons why his invention is has more advantage than the existing. So the inventors has to respond to it. So you will have a set of objections, and those objections has to be replied. Say the objections will be like your invention lacks some novelty because there is an existing technology which is using the same process or which is the same product. So I have to quote what is the advantage, what is the technical advancements in my invention, and you have to respond to that. So if the controller is satisfied, he may go for a patent grant. Else there may be a second examination report or hearing notice would be sent. So hearing notice is nothing but you can virtually or physically you can meet the controller and you can give the reply of your objections which was raised in FER or SCR report. So once all these processes are over, you have a patent grant, the controller decision, everything lies in the controller decision. So the patent may be granted or rejected. So based on how we reply and how he is satisfied, you may get a grant or there may be a rejection also. And there is one part which is called as an opposition. Not all patents go under this stage. Say there may be any interested person or like any person who want to oppose your invention. Say it's based on the patentability criteria, saying your invention doesn't have any inventive step or it doesn't have any novelty. They can raise an opposition. So that period is called as pre-grant, opposition or post-grant. That is before patent grant and after publication, if I raise that opposition, it is called as a pre-grant opposition, and after grant, if I raise an opposition, it is called as a post-grant opposition. But after grant, the opposition can be raised only for a year from the grant. So after this, they have to legally carry it out in the court. The patent office work will be over. And stage 3, so after patent filing, so I have to maintain my patent. So you know the period for a patent is 20 years from your date of filing your application. So I have to maintain it. I have to renew it every year for a period of 20 years. If I don't renew it, it comes to the public domain. Anyone can do an infringement of my patent, and I can lose my legal rights on my patent. So for the period of 20 years, I have to renew it and I have to maintain it. And I can also license it. So any industry partners who's interested in my product or process, I can license to them. So when I don't have the capacity to market it or to produce the particular product, then I can license to that. Or I can also sell my whole patent to them, or I can license it for a period of so many years also. That can also be done. And these are the team involved in a patent filing process. So you have a paralegal team which takes care of IDF document and arranging, that is giving the reference number for the invention disclosure forms, arranging the meeting between the inventors and IPM cell members. Then in addition, you saw there are so many forms has to be filed with the application. So all forms has to be filed. So that team will be handling the form filing, and you all know from patent filing still the maintenance you have cash involved. So an accounts team will be handling it. Next you have an analytics team and drafting. So who handles the prior art search? You will get your prior art search report, and who does the drafting, your provisional drafting or complete specification. And finally the tech transfer team or marketing, your patent marketing team, who will help you in helping your products to be commercialized. That is campus to commercialization. So technology transfer team will take care of it. My friend would be taking up the another session. So any questions related to this?
So now we are moving to the last session of the program, and I'm happy to introduce Amoda. A few words about ma'am. She's a graduate, BE graduate from JPI Engineering College, an MTech from SI University, and an MBA holder from Annamalai University, and she's currently pursuing a PhD in Annamalai. And her professional career, she has worked as an assistant professor in CK College of Engineering and Technology, Cuddalore, and as an IP analyst, intellectual property manager from February 2022. And she's also a woman scientist in Technology Information and Forecasting Assessment Council, Department of Science and Technology, New Delhi. And she has published 17 journals and also done 4 conferences. Ma'am, please.
So, both central and state government, they have initiated a number of programs, policies and schemes for assisting educational institution for patent filing. I have listed out here. We'll go through it one by one. The first one is PFC. It is Patent Facilitation Center. It was set up by TIFAC. TIFAC is Technology Information Forecast Assessment Council, It is an autonomous body that comes under DST, Department of Science and Technology. So what they actually do is, they will provide awareness about IPR to the educational institution. Second thing, they will train technologists and scientists. More importantly, they will help you in setting up IPM cell in your educational institution. And then they also help you in patent filing. They will provide full support for patent filing right from the beginning. That is for prior art search, patent drafting, patent filing, patent prosecution. Everything can be done in zero cost. They will pay for you. Oh, we have such kind of options, so make use of it. And then eligibility criteria for this scheme is, your institution should fall under academic institution or an R&D institution. So if you fall under any one of these category, you can avail this patent facilitation center. And also not only this, and also they will also provide maintenance for first 2 years. That is, every year you have to pay renewal fees for your patent until the 20 years of lifetime of the patent. So first 2 years maintenance fees will be taken care by them. So after that, the remaining 18 years, you have to take care of your patent. So here in Tamil Nadu, Patent Facilitation Center is available in Tamil Nadu State Council for Science and Technology. The person in charge for that is Dr. R. Srinivasan. I have given you the details. You can contact him directly, or you can mail him. He will further tell you the procedure, how to establish IPM cell here in educational institution, or they can file patent for you. So anything can be done by them. So next is Tamil Nadu Technology Development and Promotion Center. So this was established by Confederation of Indian Industry. Actually, they have set up 7 such promotion centers in India. One is in Tamil Nadu. They have given the address. So here, the major concentration is on commercialization of the product. They will help you in marketing your patented, granted patented product. And other than that, they also help you in patent filing, and everything that was done by TFC is done by them also. So here also the eligibility criteria is, your institution should be an academic institution or an R&D institution. If you fall under these 2 category means, you can make use of this scheme, and you can do it in you can do it in zero cost. So government is providing this much facility. So why can't we use them? So these 2 facilities you can make use for payment filing. And then, so you can make note of it, this address and... Then, Kapila scheme. So full form is Kalam Program for IP Literacy and Awareness. So from the name itself, you can recognize that it is named after our late President, ex-President Dr. APJ Abdul Kalam. So what they does is, they will provide financial assistance to the institution for patent filing. That is, in order to file a patent, for application you need to spend 1,600, and for examination you need to spend 4,000. This 5,600 we can get it from the Kapila scheme. So in order to register for that, so you have lot of options here. We will show you one by one. Okay. So how to get this money and this fund from Kapila? First, you need to form a committee inside the institution. That committee should have 5 members. In that 5 members, 2 members should have an IPR background. IPR and tech transfer, anything. So 2 persons should be from IPR background. There is not necessary that 2 persons should be in faculty members. You can hire anyone from outside to show for the eligibility criteria. And then another 2 persons should be an industrial expert as well as an alumni of this institution. They should fall under these 2 categories. And then the last 1 person is a legal advisor, a lawyer. So you have to hire a lawyer. So in order to register this Kapila scheme, first you should have this committee, 5 members committee. Once you form this committee, you can go to the website, and if you just type Kapila in Google Meets, you will be going into this website. Here you can register your institution. There will be option, and step-by-step procedure will be given in the form of PDF. You can look into it and you can register. And then only one restriction here is only 10 applicants can get fund for this. For a particular institution, only 10 application is granted. Okay, so this committee is formed to scrutinize the 10 patent from here. Okay, so once you submit it, the panel members from the Kapila team, they will go through the application and they will provide fund according to the examination report provided by. And then the fund will be released. And one more thing is there is no any time limit restriction that in a year, anytime you can file the 10 application. It is not necessary that within this particular time you have to file your application. So throughout the year you can submit. But only 10 application can be granted amount. So totally 56,000 will be granted for a particular institution. You can make use of it. And then next.
So 2 persons from IPR background.
Yes, ma'am.
Shall we ask you people can be there as a 2 person?
Already working in another institution.
People from outside can be backups. I will refer you some of the good people.
And the next one is MOE Innovation Cell. This is Ministry. Actually, this one is Ministry of Education. They established Innovation Cell with the purpose of developing innovation among the institution. So what they do is they will convert all the ideas into product and market. That is, they are helping us in commercialization. That is what they are doing. So to avail that policy, the eligibility criteria is these things. At least you should have one incubation center or participated in IRA ranking, NIRF ranking, NAC accreditation. You don't need to satisfy all these criteria. Any one is enough. Like if you have NAC accreditation, you can go for it. So you have options. And then if you are a government deemed university means you can apply for it. So you have to satisfy just one criteria. That is not necessary to satisfy all the criteria. And then here also the same procedure. A committee should be formed. So 3 category wise we have to form a committee. First one is faculty representation. In faculty representation, first you have the head of the institution. He should decide a president for faculty. So that person should have an IPR background. That is necessary. And then second is convener. Convener is the direct point of contact between MOE and your institution. So they should hire the convener. And one more thing here is within 1 month after selecting the president, you have to complete the entire procedure for this innovation cell setup. So that is the deadline for this MOE innovation cell. Once you are decided with your president, you have to make it fast, the procedure. Okay. Then other than this, so under MOE, yes sir.
What is IPR background?
Sir, he should have experience like.
Experience or any certification or license?
No, he should have work experience.
Either you could have filed one patent or trademark anything, or you have some knowledge about IPR is enough.
Okay, that's what.
No, you don't need any technical expertise or
else, suppose I can take a course in the NPTEL. At least.
He says
Okay.
many members are there it seems and we can.
Yes, at present, faculty members say, IPR background, we are thinking that outside. Okay. Okay, so you must have a knowledge at least, otherwise any course.
Faculty representation has to be internal.
IPR and army Indian understanding, right?
Basic knowledge of
Basic knowledge, okay. Otherwise you can get it from the NPTEL courses. Thank you.
Then other than president and convener, you should have coordinators. There are more than 6 to 7 schemes are coming under this MOE innovation cell. For example, this NIRF ranking, that ARIA ranking, everything comes under MOE. So if you decide that I am going to take part in this ARIA ranking, you should have a coordinator for this ARIA scheme. So similarly, Kapila scheme is also a part of MOE innovation cell. So if you desire to get fund from Kapila scheme means you should have a coordinator for Kapila. That's how it's works. So there are totally 7 to 8 schemes comes under this MOE innovation cell. So based on your requirement, you should hire the coordinators. So the coordinator, after coordinator, there should be members of this faculty representation. You can have n number of members. There is no limitation for that. So for faculty representation, you need to decide upon president, convener, coordinator, followed by a member. That is enough for faculty representation. And then student representation. There is no need for president and convener here in student representation. Here we need only the coordinator. For example, if you plan to have ARIA and NIRF meet, you should have a coordinator for ARIA, coordinator for NIRF. And here the coordinators are not restricted to one person. We can have up to 10 people. Because since it is a student representation, you can have a maximum of 10. And then here also student members should be there. And there is no limitation in student members. You can have n number of people. And then finally, expert representation. In expert representation, there should be 3 members in expert representation. One should be an IPR background person. Second, the industrial expert come alumni. He should also be an alumni of this institution. Third, an entrepreneur. That's it. So these are the 3 representation you should make. So once you decided all the committee members, you can go to the website and you can register and you can follow the procedure mentioned. And then the ranking. So have you participated in ARIA ranking, sir? No. Not yet? Okay, fine. So let me tell you how it happened. So ARIA is adult ranking. These 2 ranking also comes under MOE. Actually, they rank the higher education institution according to the innovation and entrepreneur skills of that the institution. Sorry. So the first column, this is the parametric. These are the metric they used to consider while ranking, that ARIA ranking. So if you see closely, means the 7th point, intellectual property, generation and commercialization. The weightage they given for IP is 14 and 19. Which is the maximum weightage given for a parameter. So if you have a strong IP background in your institution, you will easily get into any ranking. Just like that, you can get all the ranking and accreditation, MBA, everything. So patent and IPR, it's almost become a backbone of an institution. Okay. And then this is for NIRF ranking. See, the marks is 50 marks for IPR related. So, hope you can understand how much importance is given to IPR. And then, let me complete my session with a simple example. Now, you have gone through a lot of inputs regarding IPR. What is this? Can you just... What is this? Cricket bat, right? This is patentable. Now you know that the patentability criteria for an invention is novelty, industrial application and inventive skill. Do you think this is patentable?
Yes.
Yes, sir.
Yes.
Yes. Is this novel? Did you see this before anywhere? No. Then it is not. Then inventive step.
No. If you could describe it and we can say this.
So generally how the bat will be, there will be only a single handle attached to the body. So here they have attached two. So what is the problem they have worked, the basic problem they work to arrange this model is that while the ball is coming in high speed, the batsman loses his grip. That is the problem taken by this team. So in order to overcome that, they used two handle. So they placed it in such a way, 2 to 45 degrees they placed it in such a way. So if we hold the two handle means, even if the ball comes in high speed, the batsman, he won't lose his grip and he will play in a good manner. That is what is given in that invention. So this is the granted pattern, 2019, a double-handled cricket bat. If you go to Google patent and type this title, you will be getting this. So in order to get the pattern, it is not necessary, it has to be a big invention like that. It is not necessary. So just a simple invention can, if Even a simple invention can be patentable if it falls under the three categories. It is novel, inventive, and industrial application. You can patent anything. Thank you.
Registrar, respected Director, IQAC, the resource persons, and my dear faculty members. A very good evening to Ananda present over here. It gives me an immense pleasure to propose the vote of thanks on behalf of the organizing committee. Really, it's a wonderful awareness program, a real awareness program. You have opened our eyes because we are thinking IP is in a different world. Now you brought the IP ideas to our hand. So whether we are going to make it as a fruitful one or the days to come will answer. So the effectiveness of this awareness program. So at the outset, I thank our Vice Chancellor, Dr. Sundar sir, for giving us permission to organize this awareness program under the IQAC cell. So I thank him for his support and guidance. I also thank Dr. Ramakrishnan, Registrar in charge, for guiding us and to permitting us in all ways and means and the sanctioning the finance and other things. I thank our Registrar in charge. I thank Dr. Grace Kalina Madam, the Director IQAC, for the initiatives she has taken and the works she has shared and the responsibilities she has taken to organize this awareness program. I should thank the resource person, Dr. Muhammad Mustafa sir, Lata Madam and Amrita Madam for the wonderful, friendly, lively session, user-friendly session. So as you said, the IPR cell at Gindi is very friendly. So like that, you people are very friendly to help us in this initial stage. We request you to continue your support so that the IPR cell in this university will be established and we will go for the pattern, not only for the purpose of NAC, for real and fruitful practical usage of the public domain or to promote the physical education and sports sciences in the days to come. So I thank all the participants of this workshop, this awareness program for their wonderful support. My sincere thanks to Dr. Manoj and Dr. Srinivasan for their wonderful support in all the arrangements, right from the brochure to documentation of this process and the post-awareness program works. So I thank everyone for their wonderful presence and participation. I thank all the officers of this University Control of Examination and Director of Distance Education for their support in this regard. Thank you. I thank the Master of Ceremony, our English teacher, for wonderful coordinating this program. Thank you once again. Thank you.